I was distressed when you got the driving suspended charge in May. You weren't supposed to be driving. And I was even more distressed with this new case with an extremely high blood alcohol level. You're on a felony bond. You're on pretrial services, which you're not complying with the conditions of pretrial services. One of which is you're not supposed to People versus Carter Trail. Good morning, sir.
Oh.
You're with your lawyer, Mr. Luke Hofsinger. You're charged with operating with a high blood alcohol level and the possession of a firearm under the influence. Those charges were dismissed, and you pled to operating while intoxicated. The matter was set for sentencing here this morning. Matt Huff is here. He's prepared the screening report. You had several arraignments this morning. Did you see Judge Pattison at 9:30?
Yes, I did, Your Honor.
In fact, I thought you'd be in jail. He was not very happy and was trying to revoke your bond last week, Friday. But it's not as simple as that. Your new charge is operating with a suspended license, a seatbelt ticket, and then there's more coming up. Did he deal with a new case too?
No.
Well, I might as well save you a trip. I guess that other one doesn't have a date yet. At any rate,
for July.
it is.
I spoke with Jenny last week.
This is a bad set of facts. Very high blood alcohol level. The defendant was acting very irrationally. And then in the meantime, you got a driving suspended where you weren't supposed to be driving in May. And you got another drunk driving arrest in earlier the month of June with a very high blood alcohol level. You were driving suspended again. And you've got a felony home invasion pending in circuit court, and you have one here. So we're very distressed about this new high blood alcohol drinking driving arrest where he actually got released from custody because the prosecutor didn't file a formal complaint. Mr. Knopfinger, what would you like me to know?
Judge, I know many things have happened since last year, Mr. Trail entered the plea, which
He's been very cooperative.
I do represent Trail in the pending felony. Upstairs.
He is on
Pretrial
release.
Melissa Bliss. I can tell you there. Having discussed it with Matt, I think that Mr. Trail should be considered for sobriety court. I think when he entered the plea in this case, at that he was nearly eligible or close to. But I'm now convinced that he is eligible and should be considered for the program. The court can't consider that now. Consider here in the future. I did want to make note of a couple things in the report. The sentencing guidelines, and we've gone over the recommendation. But I would ask the sentencing guidelines, which I don't believe justify the recommendation. And the court can deviate. What I was proposed to court is that court delays sentencing today. This case rolled into a sobriety court sentence.
With his high BAC case. I think clearly given the fact of not only this, the other case. I don't know how familiar that court is with that case.
Brand new one.
Brand new one.
Not much. Other than I was quite I learned of it.
Yeah, Judge. And I will say, it was very high. It was very high. I don't think I don't blood out the whole thing. But it was by some report. So I think so. Mr. Trail's perspective, it's clear that alcohol is a condition that he suffers from. In addition, it's a disease. And so from that, I would consider either delaying this days, he can be assessed by the variety court and be moved into the other case working with Mr. Trail about requirement of sobriety, and consider that, and then also the declines not consider the same guidelines they are. Thank you.
Thank you. Mr. Trail, you wanted to tell me? Yes, that's inherent. I was stressed. You got driving suspended charge Chardonnay. You weren't supposed to be driving. And I was even more stressed. It's new case, extremely high alcohol level. You're on a felony bond. You're on pretrial service, which you're not applying in condition pretrial services. What if you're not drinking? No. They took you to which occurred in March because what else? 3, 4, 6. They required to take you at 23.2. Said had 12 hours, 12 ounce or light. He also had a gun car.
I don't know. I don't know.
Alleged. He was very disoriented. I agree with Mr. Dodge. You right. I think you greatly benefited from it. And we'll for that on the next case. What order 93 1. You are in danger to yourself, to society. And they were scrambling to get you back custody after you were buck. I'm not sure after you have released. You're gonna kill yourself, or you're gonna kill somebody else, or both. Hold on, and then we'll discuss right in this next case. 90 days, yeah. You waive everything but the crime rights, base minimum $125. You can go with all those officers. I think a long period of forced sobriety will help us get off to a good start.
Yeah. You got the walls.
What's the main charge?
What?
Main charge is
Operating while intoxicated, first offense.
She's gonna tell what's someone.
This is one of those courtroom moments where frustration, patience, and reality collide all at once. The judge is not yelling and he is not putting on a show. But make no mistake, this is a serious warning delivered with control. What we are watching is a system that has already bent many times for the same defendant and is now reaching its limit. The judge carefully lays out the pattern: May, June, July, September, October. Driving while suspended again and again. Each time, the court offered a break. Charges were reduced. No operation orders were given. Payment plans were set. Time was provided to fix the problem. And each time, the result was the same. Fines were not paid. Court dates were missed. Another traffic stop followed, often late at night. At this point, this is no longer confusion or paperwork issues. This is behavior. What makes this moment especially tense is that the law itself has changed. The judge openly acknowledges it. The legislature now discourages jail for non-serious misdemeanors. Courts are expected to rely on fines, compliance, and alternatives instead of incarceration. But there is a problem. Fines only work if people actually pay them. When they do not, the system loses its leverage. That is exactly what the judge is struggling with in real time. You can hear it in his voice when he says, "So you don't care." That is not anger. It is disbelief. From the court's perspective, the message being sent is clear. Consequences have not mattered so far. And when consequences stop working, the next step is never a good one. The defendant tries to explain. She says she paid a large amount to address her license issues. She says she is eligible again. She mentions a breakup, bad decisions, and driving late at night. And here is the critical point. The judge listens. He does not interrupt her. He does not shut her down. Instead, he offers something rare. One final procedural lifeline. By continuing sentencing, the judge is essentially saying, "Fix this now, or the door closes." Once sentencing happens on a driving while suspended charge, the options disappear. License eligibility is lost. Prosecutors lose flexibility. Penalties become automatic and severe. That is the warning every viewer should hear clearly. Driving while suspended is not a small offense. It spirals quickly. No license leads to no insurance. No insurance leads to felony exposure if anything goes wrong. One bad decision can turn into years of damage. The judge even references another young man facing a 15-year felony. Not to threaten, but to show how fast this path ends. This hearing is no longer about punishment. It is about intervention. The court is saying stop driving, get legal, get stable, or the system will stop fast this path ends. This hearing is no longer about punishment. It is about intervention. The court is saying stop driving, get legal, get stable, or the system will stop being patient. Next time, there will be no continuance, no reduction, and no lecture. So the real question is not whether she understands the law. It is whether she understands that this moment was a final warning, disguised as mercy.